Hello, in this video presentation, my groupmates and I will be presenting on the topic of compare and contrast the respective approaches of the English and Malaysian law of contract towards duress as a vitiating factor. This is the outline of our presentation. We will first start off by introducing the various vitiating factors of contract. In addition, the definition of duress. We will then give a brief discussion on English law duress and Malaysian law duress. We will then talk about the similarities and differences of duress between English law and Malaysian law. Moreover, we'll give our opinions and criticisms on duress in English law and Malaysian law. We will then end our presentation with the conclusion and the bibliography. There are various vitiating factors that may vitiate a contract. First of all, duress, undue influence, misrepresentation, mistake, illegality, and restraint of trade. In this presentation, our main focus is duress as a vitiating factor of contract under English and Malaysian law. If a contract is vitiated, the consequence is that the contract is void ab initio, meaning that it is an agreement that is legally unenforceable because it is regarded as a nullity. For duress, the contract is voidable, meaning that the innocent party has the choice to affirm the contract or to rescind it. For duress, the contract is voidable at the option of the innocent party, meaning that the contract is valid so long as the innocent party does not rescind it. The innocent party has the choice to either continue with the contract or to rescind the contract. In the book of Trital on the law of contract, they defined duress, and it is the consent of a contracting party that may have been obtained by some form of pressure which the law regard as improper. There are three principal forms of duress: duress of person, duress of goods, and economic duress. Contracts induced by duress is voidable. The innocent party may choose to affirm or to rescind the contract, or set up duress as a defense when sued upon the contract. Contracts induced by duress is voidable because of overborne will and illegitimate pressure.
There are three principal forms of duress at common law. The first is duress of the person. This may include for actual violence to the contracting party or persons whom he is responsible for, or threats of such violence. To be able to avoid the contract on grounds of duress, the victim must show a causal link between the alleged duress and the entry into the contract to be sought aside. In the case of Button and Armstrong, 1976, the Privy Council held that the threats need not be the sole reason for the entry into the contract. The second form of duress is duress of goods, which is a threat of damage to the victim's good rather than to his person. Here, the development of the law has been hindered by the old case of Skid and Bill, 1841, in which it was held that the unlawful detention of another's goods does not constitute duress. On the other hand, the decision in Ashley and Reynolds, 1731, held that money paid to relieve goods which had been unlawfully detained could be recovered. The decision in Skid and Bill has come under heavy criticism, and in the case of Seaborn and the Seaborn Trade, 1976, Justice Kerr refused to follow it. Given the development of economic duress, it can be predicted that the case of Skid and Bill will not be followed in today's case. Also, in the case of the E. Villa, 1992, Lord Gough approved Justice Kerr's objected dictum, and it is clear that duress of goods can form the basis of a claim for relief. The third type of duress is economic duress. Economic duress arises usually when one party applies economic pressure on the other party, either to enter into the contract or by threatening to break an existing contract, unless the other party agrees to its variation or compromise. Actual or threatened breach of contract is a civil wrong, but until recently, common law did not recognize such a threat as sufficient to make a variation of a contract thereby induced voidable. In the case of the Scipion and the Cibotre, the court have extended the concept of duress from its earlier limits so as to recognize that certain form of commercial pressure could amount to duress. In the case of the Atlantic Baron 1979, the Privy Council had an opportunity to consider economic duress and agreed with the observations in the case of the Scipion and the Cibotre. Furthermore, in the case of Pawon and Lau Yulong 1980, the Privy Council identified four matters to consider in determining whether economic duress was present. The first matter is, did the person claiming to be coerced protest? The second matter is, did the person have another viable cause of action? The next matter is, were they independently advised? And the last matter is, after entering the contract, did they take steps to avoid of? However, the traditional approach which there must have been a coercion of will of the victim, which was such as to violate his consent, was criticized. Difficulties in this theory were convincingly exposed by Professor Atiyah. What is wrong with the contract is not the absence of consent, but the wrongful nature of the threat. Thus, claimant has to prove the existence of a sufficient causal link and show that the pressure applied was a significant cause inducing him to enter into the contract. In the case of the Universe Sentinel 1983, the requirement of violation of consent was replaced in this case with the lack of practical choice available to the victim. Two elements of duress were identified by the court. The first element, pressure amounting to compulsion of the will of the victim, and the second element, the illegitimacy of the pressure exerted. Since then, the courts have begun to use the modern approach in determining duress. In R and AG for England and Wales, the two elements were discussed. According to Lord of Hoffman, the illegitimacy of the pressure must be examined from two aspects. First, the nature of the pressure, and secondly, the nature of the demand which the pressure is applied. Generally, if the threat is unlawful, it will amount to duress. The more difficult case will be the one which the pressure is said to take the form of a legal. The more difficult case will be the one which the pressure is said to have take the form of a threatened breach of contract. On the other hand, the fact that the threat is lawful does not necessarily make the pressure legitimate. If the threat is lawful, but used to support a demand which is unlawful, it may constitute duress.
In Malaysia law, there is no specific provision which explains the doctrine of duress as the English common law. Under Malaysian law, the law relating to contracts induced by threats, or basically a duress, can be found in Section 15 of the Contracts Act 1950, the Act which deals specifically with coercion. Section 15 provides as follows. Coercion is the committing or threatening to commit any act forbidden by the Penal Code, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into the agreement. Coercion as provided under Section 15 of the Contracts Act is not the same as duress under the common law. Thus, as with English law, coercion under the Act necessarily involves some element of unfair practice on the part of the contracting party, with the aim of inducing consent on the part of the other party to the contract, to the extent that the presence of such coercion denies the consensual nature of the purported agreement. Naturally, coercion under the Act gives the party coerced access to remedies that can affect contractual rights. This, of course, brings into question the nature and the extent of threats that must be applied before the play of coercion can succeed. If the coercion is employed with the intention of causing any person to enter into the contract, the agreement is voidable, irrespective of whether the duress is the sole, the main, or even only one of the reasons for another to enter into the agreement. What needs to be proved is the presence of intention, on the part of the defendant to make the duress created by him to act as an inducement for the plaintiff to agree to enter into the agreement. Under the common law, the element of intention is precluded from the notion of duress. Once violence or threats of violence has been used against a person to the plaintiff and such violence or threats of it has caused, though not the sole cause of, the plaintiff's consent to the contract, rescission will be made available. In Malaysia, it appears the element of intention must be proved, and this may prove to be a formidable task in civil cases. However, none of these cases on duress in Malaysia appears to have argued or raised this issue. The coercion must be to the prejudice of any person. No requirement of prejudice at common law, the focus being on procedural unfairness, not substantive unfairness. Prejudice suggests some detriment to the innocent party, plausibly even substantive unfairness. Secondly, the prejudice may be to any person, contracting or third party. Moving on to economic duress. The decision made by Kerr Judge in Occidental Worldwide Investment Corp and Scapes AS Avanti and others have led to the development of the concept of economic duress. The issue whether Section 15 of Contracts Act covers illegitimate pressure in commercial transaction through the doctrine of economic duress is very pertinent. Although Section 15 is wider than the historical common law doctrine of duress, by its reference to crimes under the Penal Code and detention of property, coercion under Section 15 of the Contract Act is still very limited. Offences outside the Penal Code, or which are merely civil wrongs, are not covered. Thus, the scope of coercion is obsolete, and it also does not address the chief objection to use of illegitimate pressure. In Pao On and others and Lau Yu Long and Anna, the Privy Council held that the commercial pressure alone is insufficient and also set out the factors to determine whether there is a coercion of will such as to vitiate consent. The Privy Council then considered whether English law recognized a category of duress known as economic duress. Whether the economic pressure amounts to ordinary commercial pressure or economic duress is a question of fact to be determined by the court based on circumstances of the case. Unfortunately, although Lord Scarman and Lord Diplock in the Universe Sentinel agreed on the importance of illegitimate pressure, the case laid down only limited guidance on the circumstances in which economic pressure will be illegitimate. It seems that if the thing threatened is unlawful, or the circumstances in which the pressure is exerted amount to a crime or a tort, or it is otherwise unacceptable, the coercion will be illegitimate. Be that as it may, the focus is now clearly on the illegitimacy of the pressure exerted by allegedly guilty party rather than the traditional destruction of the will. For example, although the Malaysian courts have recently recognized economic duress under the common law, these cases were also dealt with by contracting only on the question of whether the effect or the trait was to bring about coercion of the will which vitiates consent. The concept of illegitimacy of the pressure as a criterion for judging its legal effect was not judicially considered. Indeed, this attitude shows that the approach adopted by the courts is still based on the test of whether there has been free consent that is based on freedom of the contract doctrine. Effect of and relief for coercion. Section 19, subsection 1 of Contracts Act provides that where consent to an agreement is caused by inter alia, the agreement is voidable at the option of the party whose consent has been caused. If the party exercises the option to rescind, the effects of rescission will apply and put the contracting parties to its original position. However, the right to terminate the contract must be exercised within a reasonable time. Otherwise, the courts can decide that the contract has been affirmed. In the case of economic duress case illustration, Universe Tankship Incredible and International Transport Workers Federation, Lord Diplock described the remedy for economic duress as not an action for damages, but an action for restitution of property or money exacted under such duress and the avoidance of any contract that has been induced by it.
There are similarities between the approaches of the English and Malaysian law of the contracts towards duress as a vitiating factor. The first similarity is that both law carries the same meaning of duress, which is when a person enters into an agreement, is entered as a result of threats. In English law, it can be found in the case of Button and Armstrong, while in Malaysian law, it can be found under Section 15 of Malaysian Contracts Act 1950, which states committing or threatening to commit any act forbidden by the penal code with the intention of causing any person to enter into an agreement. The second similarity is that the effect of duress under both law. In English law, contracts entered into as a result of duress is voidable at the option of the victim, while in Malaysian law, under Section 19 Contracts Act 1950, when consent to an agreement is caused by coercion, the agreement is a contract voidable at the option of the party whose consent was so caused. There are differences between the approaches of the English and Malaysian law of the contracts towards duress as a vitiating factor. The first difference is that duress under English law is governed by the common law, while in Malaysian law, duress is governed by statute, which is the Contracts Act 1950. The second difference is that there is no requirement of free consent in English law, but in Malaysian law, according to Section 10 subsection 1 Contracts Act 1950, free consent is required. Furthermore, duress of goods is expressly recognized in Malaysian law and not in English law. There is express states of duress of goods under Section 15 Contracts Act 1950. Lastly, there is no requirement of prejudice at common law, the focus being on procedural unfairness and not substantive unfairness. While coercion in Malaysian law, the coercion must be to the prejudice of any person.
By and large, a comparison of the law relating to contracts induced by threats reveals that, despite basic similarities and common features, the general meaning and the scope of the law differs under both legal systems. With that said, we believe that duress under English law of contract is better than Malaysian law of contract towards duress, as illegitimacy is emphasized as a justification for giving relief for threats in English law. The approach taken by the Malaysian courts is still based on the test of whether there has been a free consent to an agreement so as to render it a contract. Furthermore, the English cases since the Universe Sentinel have declined to lay down any further details as to what constitutes an illegitimate threat. Clearly, the importance of the criterion of illegitimacy fails to carry great weight in the Malaysian jurisdiction. To criticize Malaysian law of contract under duress, the illegitimate character of threats that would constitute duress in English law may include a threat to commit a crime or tort. However, coercion under Section 15 of the Contracts Act 1950 in Malaysia is limited to criminal acts alone. This is rather unfortunate as to a very large extent, this limited definition renders the scope of application narrower than in English law.
In a nutshell, English law of duress is better than Malaysian law of duress as it is considered to be wider in comparison of Malaysian law of duress. After thorough discussion throughout the video presentation, Malaysian law is still far behind English common law in the doctrine of economic duress. Although Malaysian courts tacitly approve the concept of economic duress, it is not applied. It can be concluded that some differences exist in between common law duress and Malaysian law, being Malaysia having the statutory provision and reference to the penal code, but it still applies common law principles. Thank you for watching our video presentation.